Hi, this is Chris McKaylee with a video podcast, and I pose the question whether the legislature can retroactively declare what an existing law is. Sometimes you might see in legislation a statement, this bill is declaratory of existing law, or this section is declaratory of existing law. How does that work? Well, in a nutshell, if the state Supreme Court has not yet determined a matter, then a court can give consideration of any statement of intent and hold that a bill does apply retroactively. Once the Supreme Court decides the issue, then they generally cannot do so. The Cal Supreme Court has said requiring clear intent assures that the legislative body itself has affirmatively considered the potential unfairness of retroactive application and determined that it's an acceptable price to pay for the countervailing benefits. Now, in 1997, there was a Supreme Court decision in Western Security Bank versus Superior Court. And here the California Supreme Court granted review of an appellate court decision in light of a newly adopted law by the legislature, where the legislature in the bill deemed it to be declaratory of existing law. And the California Supreme Court approved the statutory changes as, in fact, applying retroactively and being declaratory of existing law because it said that the legislature had acted promptly to address the issue. Now, later on in 2004, in McClung versus Employment Development Department, the Supreme Court held that the proposed statutory amendment was actually not declaratory of existing law. And that's because the Supreme Court had already finally and definitively interpreted the law. And so the court said that there couldn't be a declaration of existing law by the legislature in that case. So essentially, then the California appellate courts have determined that where there's still an appeal opportunity regarding a statutory interpretation, that the legislature can properly make a retroactive change in the law or declare something is existing law. However, when a final determination has been made by our state's high court, then the legislature is prohibited from making such a pronouncement and a retroactive determination of existing law. The point was also made clear in a 2004 case called Salazar versus Diversified Paratransit, and the appellate court reviewed an amendment to California's FEHA statute, the Fair Employment and Housing Act, that the legislature had made while an appeal was pending before the Supreme Court. And the appellate court said that the legislative enactment was retroactive because the statute prior to its amendment was ambiguous, and the legislative change occurred shortly after the court decision and before a final determination by the state's high court. A similar determination was made in December 2015 in the case of People versus Tyree. And here the appellate court ruled that the legislature had enacted a statutory change while the case was still pending, and so making a retroactive change was deemed appropriate. There was also the case of Children's Hospital of Los Angeles versus Superior Court. And here the appellate court looked at the intent of the legislature when it adopted a statutory change, similar to the case of In Re Marriage of Bull, where the court ruled that it will apply a statutory change retroactively if the court finds that the legislature intended the change to be retroactive, unless it was unconstitutional to do so. So in that case, the court posed 4 instances where retroactivity would be impermissible. The first question is it an ex post facto law? If yes, then it's prohibited from being applied retroactively. Second, does it impair the obligation of a contract? If yes, it's prohibited from being applied retroactively. Third, is a vested right deprived without due process? If yes, then it's prohibited from being applied retroactively. And fourth, would it violate the separation of powers? If yes, then it would be prohibited from being applied retroactively. So I think there are three main points that can be taken as guidance to lawmakers and practitioners when they attempt to make retroactive changes to a California statute that's in existence. First, did the legislature enact the change in law promptly after an adverse court decision? In most instances, the legislative change needs to be made within a short time period of the court decision. Second, has the Supreme Court rendered a final decision? If yes, then the legislative enactment is most likely to be deemed only prospective in its application. And third, is there some amount of ambiguity in the statute that was amended? The courts are usually more inclined to allow a declaration of existing law and a retroactive law change when the ambiguous statute was amended by the legislature.